Hello, fellow Facebook friends, and welcome to Legal Live, where we discuss your legal concerns with the Tom Riley Law Firm in Cedar Rapids. The following is a paid sponsor segment, and the thoughts, questions, and beliefs are those of the Tom Riley Law Firm and not KCRG TV9 nor Gray Television. During Legal Live, if you have any legal questions, comment down below now, and we'll get to as many of your questions as we can. We're visiting with Peter Riley, who's here to help you. As always, we'll begin with a couple of great questions from our last episode. And Peter, our first question comes to us from Stanley, who says, I'm curious about the rules of the road for e-bikes and scooters. With so many of them on the streets these days, it seems that the riders should follow the same rules as cars, trucks, etc., but they don't. Do they have the same rules as motorcycle riders? In other words, glasses, helmets?
Yeah. That's a very good question. First of all, let's talk about, who can be on the road. And the main limitation is only pedestrians and people in, motorized wheelchairs can be on a sidewalk. No one else can be. And you'll see bikes, scooters on sidewalks. They're not supposed to be there. Anyone, beyond a licensed motor vehicle, which would include motorcycles and, four-wheel vehicles, they are allowed on the roadways and they have to follow the law. But if you're on a motorized scooter or one of those low-speed, not a motorcycle, but a motorized bike, you can only operate on the roadway, and you have, except for interstates and stuff, things with minimum speeds and all that can bar that type of traffic. But otherwise, yes, they have to be on the roadway, and they're supposed to follow all of the rules of the road.
We'll begin with a couple of great questions from... I'm so sorry.
Yeah, that's but anyway, so the fact is that they have to, but they have to follow, they're supposed to follow the rules. I mean, and how many times have you seen a bicycle go through a stop sign or something like that? They always do. With respect to helmets have not been required in Iowa since 1976. I remember I was a guy who was a professor of mine when I was in law school, speaking at a CLE program, and made some comment about, motorcycle, all the helmet law has accomplished one thing, and it's made for a lot of organs available for donation, because you're in a motorcycle accident without a head.
Yeah, boy.
Without a helmet, you get a head injury, and so you're clinically dead, but they can keep you alive for a while to, harvest the organs. But other than that, no, you don't have to wear a helmet. But if you're on the roadway, you're supposed to follow the rules of the road.
Okay, well, that's interesting. I happen to know a neighbor who, probably in his early 40s, who was riding one of these scooters, these electric scooters, and just got his foot caught and destroyed his ankle. He'll never walk the same again. He's a very athletic guy and always working out, swimming and everything, but that really messed him up, and it wasn't for lack of, I don't know, I can't speak to it because I wasn't there, but holy cow, I feel bad for a guy. I just feel like they're very dangerous.
Well,
you need to take precautions.
Well, I mean, the law doesn't say you have to wear a helmet even when you're riding a bicycle, but who would ride a bicycle without a helmet?
Yeah.
I mean, it's just, there's some things that are basic, and, most people, want to avoid damage, and of course, injury on any kind of vehicle. I mean, you might remember one of the Olenzaks severed the Achilles tendon on a golf cart injury at Fakebine years ago.
I remember that.
Yeah, so I mean, anything can happen.
Peter, we just got a question from Molly, who asks, can you explain pro bono work? Do you ever do cases for this?
Okay, pro bono is Latin for the good of the public, or the good of whatever, and it's it applied to law. It's the concept that if you do work for a good cause, then you can that without intending to charge. That's called pro bono work. And for example, there was a time when to practice in the federal courts, you had to periodically take on a prisoner case, and I remember Todd Becker joked about a case where a prisoner sued the state because he felt that the doctor's prostate examination of him was too rough, which led to a few titters, you might say. But in any event, that's no longer a requirement. There are a lot of programs that exist to that. I sit on a local board, the Ecumenical Community Center Foundation, and we have an affiliate organization, Margaret Bach Housing, and I do a lot of work for the Margaret Bach Housing people. And, other things, when I'm doing stuff, or like the church was doing a refinance, I examined their abstract and gave a title opinion. So, yeah, I do that. Usually, in my case, because I have some type of relationship with, a nonprofit that needs some help. So I'm always happy to do that.
Are lawyers required by law to do pro bono work?
No, there's, we have a general ethical idea that, lawyers should, to the extent they're able, devote some of their time. But the only mandatory pro bono, like I said, was for that period of time that you had to take prisoner cases. And the only one I had, fortunately, the guy didn't show up at trial, so I didn't have to do anything. Because a lot of times these guys, they have nothing better to do when they're in prison, so they file all these things, but once they're out, they don't care anymore.
Yeah.
Yeah. But yeah.
Well, Molly, thanks for the question. Go ahead. Did you have something else to add?
It's just that, lawyers, we're like everyone. If you can help people, it's just like people that have other skills to help with charities and things like that.
Okay. Molly, if you've got a follow-up question to Peter's answer, please put it in the comments section now, if you would, please. And thanks for your contribution to this effort. Peter, our next question comes to us from Missy. And Missy says, my car was struck and damaged while parked on the street overnight, but my neighbors have refused to turn over their doorbell video to help us learn who was at fault. Can we legally compel them to turn this over?
Well, as a practical matter, you can't, because anyone who has a lawsuit can subpoena information from third parties. And so if you were suing somebody who you thought did the damage, once the lawsuit was filed, you can have the clerk of court issue subpoenas. In fact, they now let lawyers, we can fill out the subpoena. In the old days, you had to get it stamped at the clerk, but we can issue subpoenas for a given pending lawsuit. But the problem that Missy has is she doesn't know, who did it, so she's not going to sue, so no basis to get a subpoena issued. So the only option would be to contact law enforcement and then tell them about the accident and tell them that a potential source of evidence would be the camera, and then they might be able to obtain it as part of the criminal investigation.
Interesting.
Interesting. As I've said before, we talk about some of these questions that we get before the production, and someone said, "Well, it was probably the neighbor who hit him. That's why they won't give it to him."
Well, there's that.
Yeah,
there's always that possibility. All right, we've got another question, Peter, that came to us anonymously, and it reads like this. My ex-husband has anger management issues. Last night, while spending time with our 3 young children in his home, he got mad at them and punched a hole in his wall, scaring the kids. What can I do to protect our kids from such quote-unquote routine acts?
Well, and here's the problem, is, a decree was entered in the dissolution that basically provided, what visitation rights the ex-husband has. And so you really can't change those unless you have a change in circumstance. And so, and it's suggesting that, if the ex's anger management problems were in existence and known at the time that the decree was made and the rights got provided, you have a problem, because you can only modify support and visitation if you can show a change of circumstance not contemplated at the time the decree was entered. And so, so the problem is if it was always there really isn't much you can do unless you can show a change of circumstance. But perhaps, if the children were never upset in the past about this, but maybe because they're older and more perceptive, maybe you could argue, well, now that the children are aware of it, that they were accepting. But that's the hard thing is, if this is a long-standing trait, then it was something that was known when the judge decided or the parties made a settlement and a decree was made based on their settlement or the ruling after a trial. Because you can't change those unless you can show a change of circumstance.
Boy, that's tough.
Yeah.
That's really tough.
Yeah, I mean, it's just like, if you have to pay so much support, unless you either lose your job or get a better job, the support's not going to change.
Yeah.
So,
if you're just tuning in, we're visiting with Peter Riley from the Tom Riley Law Firm, and this is Legal Live, where you can ask any legal questions of Peter, and he'll answer them right here, right now. And Peter, we just got another brand new question from John, and this is interesting. We have a manager who is stealing funds from the company. It's blatantly clear, signing checks to his own limited liability corporation and not where they should go. Should we hire a lawyer? Should we call the authorities? We've already fired him.
Okay. You should do both.
Yeah. Seemed pretty.
But no, I mean, that's a good question. I mean, the thing is, the nice thing about reporting it to law enforcement is they will do the investigation, as part of their duty as law enforcement, and not, it's not, if you hire a lawyer to do the investigation, the lawyer's going to charge you for that, okay? If you report it to law enforcement, they will do an investigation, and they'll expect, the company to, provide the records and do the, run all that stuff down. But, the reason why you should do both is you'll also want the lawyer to be, while not doing the legwork that the law enforcement and the client will do, being aware of what's going on, because, in addition to, the fact that there would be a criminal penalty for misappropriation, you want to be in a position to get, the best result. Okay, if there's a crime, there's usually a requirement of restitution, and so you want to have input into the restitution order, and you also want to be aware of what's going on, because you may have damages in excess of what you could get as a restitution order, in which case you'd want to be able to bring your own civil action, to recover against the person. Now, the problem you always have, somebody gets a restitution order. I mean, most criminal cases where there is a victim that suffered some kind of economic or physical loss, they get a restitution order. But they're no easier to collect than any other job.
Yeah.
So, but yeah, I mean, do both. Law enforcement will do the heavy lifting, and the lawyer will be there to, make it go in the client's benefit.
That's great advice. And John, that was a great question. We really appreciate you submitting it. If you've got a follow-up question, John, please put it in the comments section now, and Peter will respond to that right away. All right, we have another question, Peter. It came to us from Cindy. And Cindy asks, how long does a Supreme Court judge have to decide on a workers' comp case? And if there isn't a timeline, why isn't there?
That's a good question, and one that can be frustrating when you have delays in the resolution of a civil lawsuit. There is no time deadline either for the appellate court or the district court to decide things. And the reason why there isn't is basically one, the Supreme Court, in conjunction with legislative approval, writes the rules of procedure, recommend them, the comment periods, but they're not going to want to put themselves under necessarily an arbitrary deadline. They'll try and do the best they can, but sometimes things take a while. At the district court level, where you have the judges that hear cases and have trials, for a long time there has been a rule that basically says if anything has been pending more than 60 days from when the case was tried and any post-trial filings were made, they have to report. And it's you know, it's well known. There's always, there's always one or two judges in any district, or at least in ours, that are very, very slow in getting out rulings. You know, there are some judges that are very quick. There's some that, you never know, but they'll take their time, but you'll get it within some time frame. And there are some where it can take a very long time. And clients complain about that a lot. And I remember had a case where the other side was not happy with the fact we tried this case in the fall. It was in the spring. There still hadn't been a ruling. And obviously the client was telling the lawyer on this side, I want a ruling, do what you can. So the lawyer writes a letter to the judge. Of course, I get a copy of it because you can't communicate to a judge without all the other people involved knowing about it. And basically says, my client is, wondering when we might get a ruling. And he got a ruling in about a week. And he didn't like it one bit. So, I mean, that's the practical problem is, what are you going to do? Say, hey, judge, when are you going to rule, I mean, that. And by the way, that same judge, I had another case. We had tried the case in the fall, and it was it was in early summer, and I ran into him at some, something down at the courthouse, and I saw him. We just chatted briefly, but I tell he had that embarrassed look, like, I haven't ruled on that case yet, and so we got a ruling pretty quick. I didn't say anything about it. We got a ruling fairly quick. He padded the ruling by extensively quoting the statutes, It looked like a long thing, but all he did was fill it with, the language from the statutes. But, I mean, it is a problem, and there have been, occasionally, there's been a couple of judges over the years in our district that have just been really slow.
Well, that brings to mind a question that just popped into my head. Are judges allowed to use AI in cases like that?
Well, that's... I mean, the AI, processes, people could use that, but, I mean, AI right now for legal stuff, in fact, they were just talking about that. I'm doing an online seminar today for continuing education. They're talking about all things with AI. AI is not very reliable. They hallucinate cases. When this first started coming out about a year and a half, 2 years ago, you hear about lawyers submitting papers. Yeah. And they make up, you have to cite cases as legal authority. They make them up. I think it's called AI hallucinations or something like that. And so if you're doing something that is initially generated by AI, your legal obligation is you have to review it. You have to look at what they cite as cases to see if, number one, they exist, and number two, do they say what the thing says they were? I mean, here's the other thing. I mean, you have to, if you're reviewing something a younger lawyer wrote and they cite a case, sometimes they're in a hurry and they just take what, a summary, and we have, ways to look up cases, and they summarize what's said, and you say, okay, is that what it said? I said, well, that's what it said in the head note. I said, well, did you read the case? Is it in there? I mean, that's the thing. When you're submitting something and you're quoting a case as holding for some legal proposition, you have an obligation to confirm that's what it says.
Right.
So, I mean, and that's one of the reasons why, I mean, a lot of areas of the law, the law is pretty consistent. Any given divorce case, these judges probably have fairly stock language they use for a lot of stuff. But if you're in an area where there's not been a lot of, litigation, a lot of cases, and where it's an out of the ordinary thing, you've got to take some time, to figure out what is the appropriate law that you can refer to and cite as authority.
Good point. Well, it's interesting. It's a new world, and AI is a big part of it. We've got time for one more question here on Legal Live with Peter Riley from the Tom Riley Law Firm. And Peter, this one is timely. Let's put it that way. And it comes to us from Terry, who asks, how may I begin to file a lawsuit against Trump for fees associated with his stupid tariffs? I am very serious.
Okay. Well, first of all, there is a very specific procedure to file a claim based on the tariffs. And I did read the Roberts majority decision that, stands as what the court, decided, approved by a majority of the judges. It's fairly short. I haven't read the numerous concurrences and dissents. So, just going by what can be considered the opinion of the court, you have to file in the Court of International Claims. There's a very specialized court because there were two cases that the Supreme Court decided. One of them was filed in district court. The federal government moved to transfer it to the Court of International Claims. The other case was filed in the Court of International Claims. And
why international claims?
Well, there are some specialized courts that hear certain types of cases in the federal court system. Like if you have a claim against the government,
and the tariffs are
and so
against other countries.
I mean that is the court that has jurisdiction. And in that case, they basically said, the case was filed in the Court of International Trade, is the one that established the legal principle. The other case that was filed in the district court was dismissed on the basis of district court. The general district courts did not have jurisdiction. So you have to file in the specialized court, and you can only file if you paid a tariff. Okay, I mean, if you're, a retailer that lost money because of the tariffs, you don't have a claim against the government. The only people that can make a claim are those people that paid the tariff.
So Terry's probably out of luck because I'm guessing he didn't pay the tariff directly.
I mean, if he didn't, then look, if everybody could sue the government whenever they did something dumb that affected the economy, where would the end of it be? And it's unfortunate because the tariffs have been a major problem. The funny thing is, they were trying to do Trump a favor, to give him a face-saving way, to do this, but not his nature.
No, it's not.
I'm going to do it this way. So there we are.
I guess time will tell how that ends up. Speaking of time, we're out of it for this edition of Legal Live, but we will be back next week with another segment of Legal Live, sponsored by the Tom Riley Law Firm, where they know that something shattered can be beautiful again. If your life has been shattered by a work injury or auto accident, reach out anytime to Peter Riley or his partners at trlf.com, the prestigious Tom Riley Law Firm, where they make families whole again. Thanks for watching. See you next week.